Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Seeson. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Seeson.
Hi, everybody, and welcome to the March 2025 edition of the Third Fridays podcast. Quarter one is almost over, which is insane. But just to recap you from last month, we had two of our former paralegals appear on the podcast. So my thanks again to Derek Romberg and Ryan Wallace. They talked about the different paths of life that they came from to become paralegals here and their journey towards law school. And eventually becoming attorneys. That was a really, really great conversation, one of my favorite ones of the last few years, and the hit rate's going up, so thank you to their families for also listening to that one as well. Today we've got a really interesting conversation about legislation. So a lot of you New York State nerds about the law can definitely listen in and see where you think this is going to be headed. But my guest for this month is my partner, Declan Gourley. Welcome back to the show, Declan.
Thanks for having me back.
So I would think that if I prefaced this podcast by saying legislation and you would pitch it to people that were in the industry, in the know about what we do, I would say most people would think that we're going to talk about the mental stress legislation.
Right. Yeah, that's the number one thing we're going on right now.
But I think that is a very straightforward thing, right? You have a standard that typically the average employee would have to show a particular higher standard of mental stress. And now the legislation is proposing or is going to be enacted that they don't have to do that, right? It's a very clear cut, very straightforward thing. And while we can certainly cry foul about it and talk about what we're going to do, I think that is actually, I don't want to say it's beaten, but people have definitely discussed their feelings on it in various forums about it already.
Right. So what are we going to do today? Cry some more about, I guess, obviously we don't view it as in a positive light, but we're going to belabor it. Yeah.
I think that obviously it's just funny now because we said we're not going to talk about it, but now we are. But to that point, I think it's very hard pressed to say that the average person experiences stress in their job compared to that of a first responder, right? A police officer, a firefighter, emergency medical technicians, those types of people experience stress greater than you and I. I think we can typically agree with that. But then again, I don't want to dispute the idea that, people don't have legitimate claims outside of those particular employments. I just think that making it clearing the way for everybody might be too much.
Agreed.
But
we'll leave it at that.
Yeah, that's a topic for another day. We're here to talk about several proposals by our governor in New York regarding treatment, authorized providers, and whether or not that's good for particular stakeholders. And the reason why I asked you, Declan, to talk about this is because I don't necessarily think it's very clear cut as to whether these proposals are good or bad for employers and carriers in the state of New York. Would you agree, disagree? When you saw this, were you immediately thinking one way or another?
Usually when things come out legislatively, I think this is going to obviously be very harmful to employers and carriers in the state of New York, because I think that's just generally the way things work, unfortunately or fortunately, depending on how you look at it. But I think that if you take a step back on this one and look at it from the overarching theme, I think might be not as negative as people might be assuming it would be.
Okay, yeah. So let's jump into it. The first two proposals are very similar. The first one is universally authorizing all eligible licensed healthcare providers to treat workers' compensation claimants. And you can think typically, we'll cross-examine claimants experts, and one of the chief voir dire or, qualifications questions are going to be whether they're authorized by the Workers' Compensation Board, because If they're not, then they're not authorized to actually treat. And
Right.
it makes their testimony less credible. It makes them subject to preclusion. So off the bat, expanding the scope, widening the pool for all of these new providers to treat workers' compensation claimants, good, bad, neutral. What do you think?
I think overall good. If the intent is to, get people better after a work injury, the more options they have for treatment, then presumably the better, right? And making it less difficult for them to have to, especially I think upstate further, up by the Canadian border, treating doctors can be quite far away from each other. And if you have to jump through hoops just because a doctor's not coded by the Workers' Compensation Board, it just makes it more difficult to get to those doctors. Maybe you don't have transportation, whatever the reason may be. I think that the more you have, presumably the better you'll have options you'll have.
Right. I don't think that can be denied at all. The board cites that 10% of these eligible healthcare providers take the authorization step to become coded by the board. And so now making it automatically eligible, you're now saying to a claimant, you can treat with whomever you want as long as they're an authorized licensed provider. And expanding that scope, giving them access to better treatment actually could be better for everybody involved, right? Because, one of the chief goals of workers' compensation is to bring an employee back to work. And I think that people generally don't associate that with the average claimant's expert.
Well, at least in litigated cases, I agree with that.
Sure. And so maybe that then goes into the second proposal, which is now saying that residents and fellows within hospitals and, certain practices would now be able to treat workers' compensation claimants under a supervising provider. And I guess in a sense, expanding the network within that facility that a claimant is used to now treat them, right? You don't need to have the doctor that's on call or the doctor that's affiliated with the hospital. To me, I think that this is kind of neutral. I don't think it really changes the scope, especially compared to the first one. What do you think about that? Do you think that there's any difference between whether a resident physician or a fellow physician treats a New York workers' comp claimant?
If we went back a few years ago, I would say that it should be a treating doctor, but we've expanded this so far now. You've got nurse practitioners, physician's assistants. I don't see how someone that's just doesn't have their medical license yet, but they're treating or they're examining under a treating doctor is any different than those individuals. So I can't see how that would be.
Yeah, that's a good point, right? Years ago, we were using that as part of our litigation arsenal whenever there was a physical therapist or a physician's assistant doing the examining. But now that they're authorized to not only do that, but they can request treatment. Some of them can comment on degree of disability. It's a pretty big expansion of the scope of what they can do. So allowing resident physicians to come in, I think is more or less a neutral facet. So you'd think that, okay, if this is already good for workers' compensation claimants or really just in general everybody, I'm going to go back to what you said you thought when you see typical legislation. You think that it's automatically going to be bad for the employers and carriers because that's just the trend of how the legislature has developed in the state of New York. And so now we get to some of those things that may have those symptoms of how we're feeling, right? So the third one has a proposed increase to the fee schedule in a sense so that the providers who don't want to go into workers' compensation because of the lower fees that they can charge are now incentivized to come into that pool, right? We're going to take away your procedural step of becoming authorized by the compensation board, and now we're going to increase the fee schedule. On the surface, higher cost for our clients, our prospects here. Is there anything that you can think of that could make it at least neutral or maybe even positive for our clients? Because obviously costs are rising across the board. Is there anything that could make this positive?
In terms of the cost going up for treatment?
Yeah.
I think that would be a difficult spin. I maybe not so much spin. I just think that overall, if you really want to open this up for more doctors and treating providers to see injured workers throughout the state of New York, and you could put that on paper that they're allowed to do it, but what treating doctor's office is going to realistically say we're accepting workers' comp claims if they know they're going to get paid potentially pennies on the dollar from what their usual customary charges are. So if you really want this to come in, you really want to put some, meat behind this. The only way to truly open the door up for more treating providers to come into the system and actually treat injured workers is if you actually pay them and allow them to want to come into the system.
Yeah, that's a good point. I think also it's going to depend on how much that fee schedule is increased, right? I would imagine that, again, comparing it to like a mental stress standard, it's like either one or the other when a bill gets proposed and then enacted into law, right? When you're talking about an increase in cost, there are typically, lobbyists, groups that, talk about their feelings on the matter. And sometimes the first iteration of an increase in the fee schedule isn't going to be the last, or it isn't going to be the final one. And so I think that if it can be done in a way where it kind of reflects the growing cost of living, the growing cost of inflation and things like that, then it would make sense and allow other practitioners to enter the industry. But unless it's actually very close to what they're currently charging, what incentive does a non-compensation provider have to enter the market, right? It almost would have to be the volume that they'd recover from treating compensation claimants would, make up for the fact that their time is being charged for less revenue.
Right. And that's why I guess we see what we think are mills, like that treating doctors just have, I almost picture a conveyor belt of people just coming in and out of a doctor's office, like a stamp ready to go, and not really asking questions about treatment, or maybe having someone that's not the doctor asking questions and the doctor then signs off on it. I'm just not picturing a high level of care. I think that it's just get them in, get them out, and get as much money that we can get on this fee schedule as possible.
Yeah, it would make sense then that maybe you'd have some influx of providers that have that open availability, right? The people who say, okay, I can take on a glut of claimants or patients and then charge them at a lower rate. But then again, I would have to imagine there are probably providers out there that didn't used to take Medicare, that didn't used to take, federal entitlement programs, that now do so because of, whatever it may be, either open availability or the volume, or maybe they increase the personnel within their practice. Maybe they consolidate other practices and you see facilities buying each other up. I think that it could potentially make sense. But again, the amount of the fee schedule increase is really going to have to be compared to what these non-authorized providers are charging in their, your phrase is usual and customary. I also think that maybe there's a little bit of a tangent too, right? Because we defend New Jersey workers' compensation claims, and you have these medical provider applications where the provider gets paid on the fee schedule in New York, then does a super ethical thing by then just filing a complaint in New Jersey to get the excess, right? Is there a chance that probably stops if the fee schedule increases?
From what I know about New Jersey and the bills I see coming in, I don't think that's going to stop.
Right.
I mean, we're talking about surgeries for a knee that in New York, you might be $25,000, $30,000, and then we've seen bills in excess of $100,000 and $200,000. So I'd like to think that the fee schedule is not going to go up that dramatically, where they just say, okay, we're going to stop this. I think that the grab for that extra six-figure settlement or six-figure medical bill is probably not going to go away.
Yeah, I guess, whatever they're paying their attorneys or our adversaries in those claims is probably still going to be less than what they could achieve by just filing the medical provider application in our extremely litigious society. Maybe that's just me throwing a little dart across the board because, I feel like it's, the employers and the carriers really get a lot of flack for all the litigation in what we do. But, medical provider apps are certainly one of those things where the light should be shown on someone else. But anyway, to get off the soapbox, I think the next proposal for legislation, at least for me, is very clear cut in terms of what it means. And the proposal is that insurers will be paying for medical treatment in claims where the compensability is in dispute. Now, this has long been something that has enabled exposure to kind of be short or low in the short term, and then focus on the litigation of the claim itself, but with the worry or the risk that if the litigation is not successful, like boom, the exposure for medical is way high up because you're paying for all those disputed medical bills. So I know that there are some jurisdictions in our country where that is the case, that a carrier will be paying for treatment to the injured worker, even if the claim is disputed. But to me, this is going to ring the sound alarms for everybody here. I'm expecting this to be met 100% from our side of the table as something that's very, very negative. But maybe, Declan, you can explain why. Why is this such a negative for ours? Or if you don't believe that it's a negative, maybe we can educate our side of the aisle on it.
I just truthfully don't see why this is necessary. I mean, it just seems like a strange thing to throw into the rest of the bill that's being pushed in terms of the changes being made. You know, as is now, I would say the majority of people that are going to their doctors and it's a disputed claim, the bill is getting paid by another insurance company. I don't think it's being left to the claimant to pay that bill. I mean, maybe I'm putting my head in the sand here, but I would think the majority of these claims that we see, at least someone is presumably paying that bill, or there's a hemp coming down the line, or a matching coming back and seeking the money at the end of the day. You know, if I could see why the argument would be if the claimant has no insurance, that, you know, they're not going to get treatment for something that they necessarily need treatment for. If the carrier wasn't paying for the medical bills, then maybe they just stopped doing it. They stopped going to the doctor because they were afraid of all these bills piling up and then never getting paid back. But as is now, it feels like it's, you know, workers' comp insurance carrier on this side, you know, regular health insurance on this side, and divvying up the bills. Who's responsible once the claim is denied? I don't see why it doesn't maintain status quo at this point.
Yeah, or even if there isn't another insurer to pay for it, we often see the disputes held in abeyance pending establishment of the claim. Like, you know, once that resolution of the claim is complete, or sometimes we see that the bill is found for the carrier without prejudice to resubmission if the site or the claim is later established. And I think that the board may, or the board, I'm not saying it's the board, but it might be the state that's proposing it here. The reason that they're saying that this is compelling is that they're saying that it ensures workers are no longer caught in the crosshairs of a dispute and can get the timely treatment they need, while also ensuring providers will get paid. And I think that it's almost a little bit of a misnomer here, because from the claimant's perspective, if they fall into that trap of seeing a provider and the provider says, I don't take workers' compensation insurance, or I don't treat workers' compensation claimants, how often do you see a claimant just saying, well, I guess I'm out of luck and I'm never getting treatment? And
right.
Like how that is so rare that you then see the docket not like filled up with medical records, right? So the dispute of the claim is not really the reason why treatment is stalling, right? I'll tell you another thing. How often do we see our clients in good faith authorizing treatment without prejudice, right? The PAR system has, you know, its certain issues, but our clients often authorize even surgeries saying without prejudice to causal relationship, without prejudice to our compensability arguments, almost telling the claimant, if you believe that this is so emergent, you can go get this treatment,
right?
But your provider just has to know that that is not going to be resolved until, you know, compensability is decided.
And at the end of the day, if what happens if it's not compensable? The carrier is not responsible, but the bill's been paid for. Now who's responsible for it if the carrier already paid for it? How is the carrier getting reimbursed?
Right. I would also say, you know, to your point too, how often does a dispute result in the claimant now having this $50,000 expense to pay for treatment, right? I mean, sometimes we do see those providers send bills to the claimant because they want that paid, but I don't think I've ever seen a claimant saying, I'm going to pay for all of my treatment while the dispute is happening. Which
makes me think that this is clearly like the medical providers lobby, or whatever, whoever's lobbyists in Albany doing this.
Making it sound like it's for the claimants.
Right. And at the end of the day, it's probably a situation where the medical bills pile up, claimant's not responsible, and the medical provider's sitting going, Okay, but I just laid out $20,000 in medical services. Claimant's clearly not going to pay for it. Where do I get my money from? And they're left holding the bag, basically, is how the proverbial phrase.
Yeah.
So
Yeah.
that's who I would say is the push behind this.
Holding the bag is an interesting phrase in and of itself too, because providers, they're making that gamble every single time, right? Like if this is not related to the claim, then, the claimant is telling me that it is, and I'm going to treat the claimant. I'm taking that risk too, that I'm stuck. And a lot of them have those relationships with claimants' attorneys' offices that constantly refer them files. So it's almost like they're contractually agreeing to that risk by saying that I'm going to treat this claimant in furtherance of the chance that the claim is established and I will get paid. And we all know that in most cases that works for them. So to kind of put it at the forefront for medical providers, I think that one really doesn't make sense. I don't think it moves the needle. So let's go to the last one here. Last one is that the law will permit carriers to pay for medical treatment without accepting liability for up to 1 year. So the board or the state is saying that it provides more transparency. It requires carriers to notify injured workers that such payments are being made and that their claim will automatically be accepted at the 1 year mark unless the case is controverted.
This is 21A. I mean, we've already got a statute that says basically carrier can pay a claim without prejudice for up to a year and then timely deny it. And if they don't deny it timely, then the claim is compensable. I mean, I don't really know what the change here is necessarily.
Well, I guess the issue is, I think it would almost expand 21A. I think a lot of people use 21A for indemnity and voluntary payment of wage loss and indemnity benefits. My question here is, does this mean that if a PAR request comes in for a surgery and the carrier grants it without prejudice, does that mean they can't do that after a year? Like we see those sometimes in like year 2 of a claim, right?
No, I don't. Well, I don't read this changing that, because that wouldn't be the compensable of the claim. That's saying that the treatment's not cause related or the treatment's not medically necessary or whatever medical defense you have for that. Versus this is just saying basically, 364 days in, we're denying this because we think the claim should be denied now because of X, Y, and Z, whatever your defense is now. So I don't view those two as the same.
So you would feel comfortable, and look, I think this is kind of the point of the debate or really the discussion before everything gets finalized. But let's say you have an established back claim, right? Request for surgery comes in for a new body part. Let's call it the knee. And it's not being accepted in the claim, but the surgery for the knee is granted without prejudice to compensability defenses. Would that mean then that if the left knee or the right knee, I don't even know what I said, like, if the knee wasn't formally denied with pleadings in 1 year, would then the knee be automatically accepted?
Yeah, well, I'm not interpreting it to mean that, but that might ultimately be how they rule on this, but that's not how I'm interpreting this.
Yeah, because I think that this potentially, if you're going to allow 21A to expand and let employers and carriers pay for medical treatment for 1 year, then I think it's going to be, how is that eventually resolved after that 1 year? Right? Like, because with indemnity, if you're paying indemnity for a year and you don't deny it, we're not telling clients that the strength of a denial 2 years post-accident is going to work. Right? So, it could be much ado about nothing, but I think it's going to really depend on how those things are ultimately resolved. And a lot of times, the way the legislature writes proposals or writes bills, it's not always expected that the board and the appellate division apply it that way. So very, very interesting. Putting those 5 things together, Declan, let's go back to that first thought you had. Automatically assumed it's in favor of claimants, but not so much of I'm leaning one way or another. If you put all those 5 pieces of proposals together, where do you line up with? Positive for employers, negative for employers, or neutral?
So I don't know how much it's going to actually move the needle. I think that, in claims that are litigated, claimants go to the treating doctor, and at some point they lawyer up. They get steered towards a treating doctor that I assume is going to testify favorably, or at least give a solid opinion regarding causal relationship and degree of disability. In those types of claims, I ultimately do not see this really moving the needle, because, if the doctors that are in this expanded network are not going to find someone, to have a cause-related disability or to have a total disability for as long as possible and never getting better for 2 or 3 years at a time, who's going to refer the claimants to those treating doctors? Probably nobody, The cases that are not in active litigation, the ones where someone gets hurt, they truly want to get better, and they want to find a doctor that's going to make them better, not someone's going to fill out the forms as best as possible to help their case and get them as much indemnity for the next 2 years while they draw this out. Ultimately, that's the person we want to get better. I think that this gives them a broader network of doctors, and they can actually go online and see who's going to make them better, not this endless cycle of, we joke all the time. What other place or system in the world do you go in and have a knee surgery and it's presumed that you got worse, not better, right?
Right.
It doesn't make sense. Like, why would you have the surgery if you're going to get worse? But that's how workers' comp is designed, that you're going to get a permanent impairment simply by having surgeries, not. And why did you have the surgery? Like, if the end goal was not to get better, it's presumed you got worse in the way that's set up.
You're getting the surgery to get the award.
Right. And interestingly, through the testimony that I was listening to, the board's chairman, Clarissa Rodriguez, was posed the question of, isn't the purpose of having this authorization process in place currently to kind of weed out the doctors that don't know comp and that can fill out the forms properly? And my response to that really is, we've seen doctors that have been doing this for 20 years and they still don't know the definition of what total disability is. It's
right.
You'll have a doctor deposed on a Wednesday and you'll ask them, doctor, are you aware that, the total disability opinion under the guidelines is not necessarily that they can't do their pre-injury job, but any job.
Right.
And they act like this is the first time they've ever been asked this question before.
Right.
And you'll look at a medical narrative the next week for the same person from the same doctor, and lo and behold, they're still continuing to find totally disabled from their pre-injury job. And it's like, that's not the definition. So you've been doing this for 20 years and you still choose to not know what that means. So I don't think that making these doctors code it by the board truly gets doctors that are like experts in workers' comp.
Yeah, I think that question from Chair Rodriguez is certainly benign and well-meaning in theory, right? But you're right. It's not congruent with how those doctors act in practice today, right? Because almost from a debate perspective, you don't want to authorize everybody to do this if it means that the value in the production of the work that they're doing is going to be worse, right? They're not like relying on the definitions of total disability, like you said, or they're not filling out forms the proper way in order to be processed and getting paid by our clients. So in theory, that would make sense, but you're right. I mean, it's not just disability, right? Like sometimes claimants to their own detriment have their cases precluded because, a C4.3 wasn't filled out, right? And so the idea that the current landscape of doctors have that ability to do what, the state wants them to do is a very, very big problem that needs to kind of be fixed before you can make that attribution to other doctors.
Right. How long has the PAR system now been in place? And how many doctors have you seen? They file a request for surgery, gets denied. Do they do what the denial said that they're missing? You're missing documentation. You're missing X, Y, and Z. No, they just refile the same application again and again and again. It's very duplicative in nature. It's like, okay, this professional that's supposed to have been vetted to get into the system chooses not to learn what the system actually is. So I really don't think that this, bar to get in is that high to begin with. So I just don't see that being a real reason why that we shouldn't expand this. And I do ultimately think that, it might not move the needle in these cases where it's litigated, where we're trying to dispute cause relationship, because they're still going to go to the same doctors that they know we're going to give them the favorable opinion. But if someone really gets injured at work and wants to get better, again, I think that if you look on, I don't know how people choose their doctors nowadays, there's these websites that grade doctors. If you really want to get a better knee, you're going to go to the doctor that's going to make your knee better, not the doctor that's going to necessarily fill out a form and give you a total disability for the next 6 months, right?
Yeah, I think that's a phenomenal point, right? Almost that the people that are predisposed to the ends that they're seeking are going to continue to make the decisions along that way that further that end. Meanwhile, allowing access to a claimant in a non-litigated case who really wants to get better, wants to return to work and contribute to the workforce just like everybody else, this is going to be great for them and the employer, right? Having access to certain doctors, especially our upstate clients with locations where, you might be traveling a good 30 minutes to an hour to go to a different county and get an opinion on whether or not you can return to work. But you've been seeing, the person that treats you 10 minutes away your whole life. Right. I think that it's a great point about how maybe it's going to affect the claims that have the people already predisposed to doing the right thing. We don't see a lot of those because, clients don't ask us to litigate those good ones, right?
But at the end of the day, litigated cases are very small. I know we think of it as it's every case because we deal with it all the time, but overall, it's a very small percentage of the population of injured workers in the state of New York. So by and large, I'd imagine that this maybe is a net positive and that can be viewed that way. But obviously in our world, it probably doesn't really move the needle. The day in and day out cases that we're litigating these things.
Yeah. I think that's a great point. And I think that puts a nice little bow on it. It's, not to say to everyone, you have two lawyers here saying that it depends. We know that you guys are going to be frustrated with that. But essentially, what we're saying is that it's actually going to really affect the claims that maybe aren't at the desk of a defense attorney, right? Maybe they are high in number for our claims professionals and our risk professionals out there. So this could overall be positive because it provides options for not only the claimant, but the employer. But the resolution of it, the adjudication, how it's used in practice is going to be a very, very big move in terms of how this is going to be judged in terms of good, bad, positive, negative, whether it's neutral or not. That was a great discussion. What we're going to do is actually debut something new this month, a Q&A section. So I know that a lot of you send me emails and messages on LinkedIn with questions about some of the things that we discuss. So what we're going to do is if you guys have those questions and you can still use those avenues to communicate with me, we're going to take one or two of those questions and then answer it the following month just so that we can get even more participation from all you great listeners out there. And I do promise that not all of them will be for my immediate family. But this has been a great discussion. I think this is going to be a very interesting way that this legislation kind of paves the way through. Declan, thanks for being on the show.
Thanks for having me back. I'm glad to see that you've improved your technology from the last time I did this.
Yeah, if anybody listens to this and compares to the last time Declan was on the show, it wasn't his fault. But for Declan Gourley, my name is Christian Cison, reminding you to defend from day one.